Seeing we have more than quorum, I would like to welcome everyone and to call this special board meeting to order. I'd like to begin by acknowledging that although our meeting is online, together we are distributed across the unceded and unsurrendered territory of the Algonquin people. Our land is an expression of thanks to the Algonquin people for hosting us on their lands and their ongoing support in our journey of learning. And it is a reminder of the work ahead to fulfill our commitment to realizing the recommendations of the Truth and Reconciliation Commission. I need a motion to approve our agenda for this evening. And the motion is moved by Trustee Huff and seconded by Trustee Boothby. Is there any discussion on the agenda? If not, I'll call the question. All those in favor of the agenda as presented? And those opposed? And the motion is carried. This special board meeting was called to deal with a code of conduct complaint, a complaint against one of us, and one which involved a member of the community. This issue has been of significant interest to our community, and in particular our Black community. To all of you who have been waiting patiently since the end of March, we appreciated your patience as we worked through the procedural requirements of our code of conduct process. An investigation has been carried out, and tonight we will consider the results of that investigation, determine whether a breach of our board member code of conduct has occurred, and if we find in the affirmative, decide what sanctions, if any, should be applied. In accordance with legislation and policy, I note that the trustee named in the complaint, Trustee Blackburn, is entitled to be present, but may not participate in our deliberations on the matter. I also note that the trustee who made the complaint, Trustee Boothby, is present and is entitled to participate in our deliberations on the matter. Throughout the process, the Vice Chair and I have been responsible for managing a formal review of the complaint in accordance with our board member code of conduct policy. In that, we have had the guidance of legal counsel and the support of staff. And our counsel, Mr. Lynn Harnden, is present tonight if additional legal guidance is needed. If questions arise which require privileged information, we will have to resolve in camera to receive the answers. At this time, is there any member who has reason not to participate in our discussion and deliberations on agenda items 3.1, 4.1, and 4.2 pertaining to the code of conduct complaint? I should add that our legal counsel advised that the courts have consistently held that the determination of whether a reasonable apprehension of bias exists is based on the circumstances as they existed at the outset of the proceedings. On that basis, I don't think it is reasonable to recuse for the investigator's report and the question of breach, and then participate if the question of sanction should arise. So I would like to recognize Trustee Evans. Unmute yourself, please, and go ahead.
I definitely didn't have my hand up first. So I'm going to...
Point of procedure, privilege, whatever you want to call it, your ruling. I'd like to understand your ruling, if I may.
I would like to invite counsel to address that issue.
Well, my dispute with you is that if someone recuses from the first part, finding guilt, and if it then goes to the section part, sanctions, that the people would be, someone who recuses from the first part would automatically be recused from the second part. I'd like to understand why that, to me, that does not make sense.
Mr. Harnden?
My observation, Trustee Ellis, is that if a trustee elects to recuse themselves, it's presumably on the basis that they perceive themselves as being in a conflict of interest. Perhaps by reason of the fact that there's public evidence that they had prejudged the outcome of the proceeding. Once the trustee identifies having a conflict of interest, that would not only stand as a barrier to the vote on the initial resolution, but it would also place at risk the propriety of the discussions and the vote on the selection of sanctions. It might be argued that the trustees' acknowledged conflict of interest would represent a breach of the duty of fairness to the trustee whose conduct is under scrutiny. So on the basis of that logic, I would say that once a trustee determines that they have a conflict of interest, it would be inappropriate to not only participate in the initial resolution, but also in the discussions regarding the second resolution. I don't think it would be improper once those resolutions have been addressed by the trustees for that trustee to make comment on why they made their or reached their conclusion that they had a conflict of interest, or on the subject matter generally, but at that stage of the meeting.
Yeah, I'd like to challenge the chair's decision that if recusing for the first part, that a trustee does not have to recuse themselves if it goes to sanctions for the second part, because then the conflict, if there is a finding of guilt, then the conflict of having predetermined before this evening is no longer moot. And I'd like to challenge the chair on that.
Thank you, Trustee Ellis.
I'd also like a recorded vote, please.
I have not made a ruling on that because only the trustee who is considering recusal has the authority to decide whether or not they are going to recuse. It is that trustee's decision, whatever the consequences. The board itself and I as chair do not have any authority to order you or any other trustee to recuse from any or all of the parts of this particular process. All I am saying is making it clear that our legal advice is that if you are recusing from one part, you should be recusing from all parts. That is your decision.
Okay, thank you then. I don't need to, I won't challenge the chair now with that clarification. Thank you.
So I have Trustee Lyra, who is still has the floor. Trustee Lyra, you're muted.
Before the board today, we have two decisions. We have a decision about whether or not there was a breach of the code of conduct, and we have a decision about what an appropriate response to the breach, a possible breach of the code of conduct might be. I am of the opinion that I have prejudged whether or not a breach of the code of conduct was met. I do not believe I have prejudged whether or not or what an appropriate sanction would be. So I'm going to be recusing myself from 3.1 and 4.1 of the discussion.
Thank you, Trustee Lyra. I have Trustee Schwartz next on this.
Yeah, so I just wanted to ask a question actually pertaining to Trustee Ellis's question about whether or not participation in both can occur. And if I could seek legal counsel opinion on should there be sanctions if there's guilt found in the first part, if sanctions are put forward in the second part. The process would go through an appeal and potentially a judicial review. Is that correct?
That's correct.
And in the case of going through either appeal or judicial review, the risk to having a potential conflict of interest from a trustee participating, as identified a potential conflict of interest, participating in both Part A and Part B. Could you please speak to the potential risk of an overturn of decision?
In an application for judicial review, it could be argued by the trustee who's the subject of the sanction that the participation by a trustee in the discussion of the selection from a range of sanctions that are available under the Act and under the Code of Conduct, and participation by a trustee with an admitted conflict of interest in that discussion had a consequence of breaching the trustee's entitlement to a fair process in this proceeding. That's my judgment that would put the board at risk of a finding by a court with associated costs implications if that were to occur.
Okay, thank you very much. That clarifies.
Thank you. Thank you, Trustee Schwartz. Trustee Ellis, I have you next, but I note that Trustee Lyra's hand is still up. Did you still wish to speak? Okay, it's gone down now. So Trustee Ellis.
Thank you. I'd like this to be part of the record, and I can send my text to board services. The initial report of this incident and Ms. Blackburn's bullying is consistent with past behavior, and the evidence of the original Facebook post is
Trustee Ellis,
irrefutable.
I'm going to stop you there.
I therefore have no problem with
Trustee
calling
Ellis?
Ms. Blackburn. Yes, Chair.
Before we are making our decision, you should not be speaking as to the merits of the investigation or the incident. You should simply be indicating to us at this time whether or not you are going to recuse yourself and from which part, so as not to prejudice our discussion.
Okay, I won't recuse myself.
Is that everything?
I'll participate. I'll read my statement during the meeting as a participant.
Thank you. That brings us then to item 3.1, the investigator's report. The investigation of the complaint has been undertaken by an independent investigator who will be presenting his report in a moment. Having the investigator attend to present his report is a new step for us, intended to assist the board. After his presentation, trustees will have an opportunity to ask questions of clarification. The report before us is what we must consider in our decisions tonight. I would Mr. Zahir Lakhani of Lakhani Campia LLP to present his report. Welcome, Mr. Lakhani.
Thank you. Good evening, everyone. As you're aware, I was a third-party investigator with the mandate of doing an investigation into an incident that took place on March 27th. What I can tell you before I even started was that obviously I do not reside in Ottawa. I do not know any of the parties. And for that purpose, I was as neutral as one can be. The publication and the press releases on this matter were circulated and I was made aware of them. My view on reading them and being retained was very simply, this was a matter that I was not going to listen to what was being argued or raised in the media, and I was going to look at the fact situation that took place on that date. And going to that specific date was my mandate. I wanted to make sure that I got the evidence that I felt was fair in terms of who was present at that park on that date in order to apply the rules of natural justice and procedural fairness to this application or to this investigation. So for lack of as simply put as I can put it, two people were in that park. It was Trustee Blackburn and it was the young individual that I'll refer to by the initials SL. Those are the only two people in that park during that encounter. SL's father was not in that park. Trustee Boothby was not in that park. Nobody else was in that park except for some witnesses that came out during the course of my investigation. So for me, in order to determine the proper factors as to what happened and transpired in that park, I wanted firsthand information as to what SL experienced in that park. So my goal was simply to get those particulars from SL, verify what they were, ask questions of SL that would show that I am, well, for two purposes. One, to get clarification, and one, because I don't know SL, and simply to assess his credibility and ask the hard questions. In doing so, unfortunately, this situation was a little bit constrained by the fact that after this matter had occurred, there was litigation, or the threat of litigation, that had commenced between Trustee Blackburn and the father of SL, which required SL and his father to retain counsel, which meant that my ability to acquire information as to what happened in the park was now had to be channeled through their lawyer. Based on that, I made my best efforts to get as much information as I could from SL as to what actually transpired. And I wanted to meet with SL first because I wanted to put those particulars to Trustee Blackburn. I received evidence in the form of a written statement from SL. I reviewed that statement in detail. I summarized those allegations. I then provided a summary of those allegations or particulars to Trustee Blackburn's lawyer and herself. I then provided a copy of the statement itself to Trustee Blackburn and her lawyer, because there was parameters around which SL's lawyer would wish or require them to abide by before they were provided with that statement. I confirmed that they would adhere to that it was not going to be circulated in the media, SL's statement. Once that was confirmed, I provided that statement as well. I gave enough time for them to review and then set up an interview with myself. And then I had a virtual remote meeting with both Trustee Blackburn and her counsel. In that meeting, however, I made it very clear to Trustee Blackburn that I was not interested in having her counsel answer the question. So I allowed Trustee Blackburn to answer whatever questions she felt she needed to answer and to provide her version of events. I now, at that point, had two specific versions of events. I had SL's version and I had Trustee Blackburn's version. To me, that was more important than anything else because that was the two main parties to what happened in that park. From that point, I then determined who are the relevant witnesses. The relevant witnesses were somewhat compromised in that there weren't too many other people at that park. There was only two phone calls made by Trustee Blackburn from that park, by which SL was privy to or overheard. And those two calls were one to a local imam and one to Sue Karkner, who was basically the assistant to to Jan Harden. I then met with, through remotely and virtually, both those witnesses to confirm what their recollection of that conversation was. And I then met with two additional witnesses. The two additional witnesses I met with were Robin Brown, who represents a well-known advocacy group in terms of anti-Black racism. I wanted his perspective, and I felt it was important to hear his perspective on what he felt the actions meant to the Black community in Ottawa, or generally. What was important and was very clear with Mr. Brown was I advised him that he clearly was not present at the encounter, and most of his evidence as to what he felt transpired at that encounter was coming through the media or through SL's father. I was not interested in that evidence because he was not there. So I was simply interested in the focus on the impact of what he thinks happened and how it would impact upon the Black community or how they perceived it. I then met with Trustee Boothby. Again, Trustee Boothby was the conduit by which the complaint had come through, but was not present at that encounter. And with Trustee Boothby, her relevance was really focused on the issue of the what should a trustee be acting like? Was this behavior in line with what a trustee would do? Is this conduct trustee business, or was Trustee Blackburn simply acting in the capacity of just a concerned citizen in Ottawa who was worried about the pandemic? So those are the things I was exploring through that evidence. But in terms of what actually transpired at the encounter, again, Her evidence was not very relevant or relevant to that encounter in terms of the details as to what transpired. Neither was the imams, neither was Robin Brown's. The only key parties to that event were SL, Trustee Blackburn, the call to Sue Karkner, so Sue Karkner, and the call to the imam, and that would be the imam. So those are the four main parties or the key players in terms of what I looked at in terms of what happened at that event. Well, and that was the process by which I conducted the investigation. When I went through that investigation, of course, I ended up with the proverbial he said, she said, which is probably the most accurate depiction here because there really was a he in terms of the SL evidence and the she being Trustee Blackburn. So using the he said, she said, I ended up with many facts of the story that were aligned, but some facts that were not aligned. And once I end up in a situation of a credibility dispute, my job is very simple. I have to assess whose version is more likely to be true than the other person's version. And the way to do that is I assess credibility. How do I assess credibility? I look at things like their ability to meet with me, provide me with evidence, answer questions. Body language is another factor, but it's overblown in terms of its relevance, in terms of how we look at certain evidence. What I did look at was, did Trustee Blackburn say things that were adverse to her interests? There was clearly evidence of that. One of the most important things that Trustee Blackburn admitted to, I know much of it is going to be, well, some of the things she didn't need to admit to because it was in her Facebook post, but there was a certain factor that she did not have in her Facebook post. She never mentioned in her Facebook post that she mentioned in this detention center. The fact that she owned up to mentioning that when there was no other evidence of that comment being made except for her version and SL's version was a significant admission adverse to her interest. So that raised her credibility, in my opinion. The call to the imam and the call to Susan Karkner and what they provided in terms of the evidence did seem to line up very much with what Trustee Blackburn advised. And on top of it all, unfortunately, as much as I don't dispute the fact that SL is not motivated to lie or would want to lie in a situation like this, and I could go on and on about the fact that what stake in the game did he have, the problem I had with SL is twofold. One, I was not able to meet with him personally and review and meet and assess his credibility. Secondly, I was cognizant of the fact that a lot of what was being raised about what happened at that park was raised by his father through media reports as to what the father conveyed rather than what SL conveyed in his statement. And I was looking more at what SL was telling me happened at the park. And I don't dispute what the father is saying. And the father's probably, I understand where the father would come from and being upset about various things. But in the end, the father was not at the park. So I had to look at what SL had to say, and I gauged that through a written statement. But the benefit of SL was that I did provide questions to his written statement, gave him a chance to update me on the response to those questions, and he did provide that to me. So his credibility was strong, but in the end, unfortunately, on a balance of probability, there was some of the disputed factors I did align with Trustee Blackburn, more so because of her adverse admissions and because of the fact that she had witnesses that seemed to corroborate the events that she expressed. That being said, there was no doubt in my mind that the conduct that occurred was concerning, and my findings confirm it based on a couple of factors. Factor number one was the approach by Trustee Blackburn and the argument, or perhaps the theory, that this was a concerned citizen did not hold water. It was fairly clear that her behavior and her conduct did make a causal connection to her being a trustee. There was no doubt that she uses Facebook, for example, as a way of promoting OCDSB business. She engages in it. Her constituents are her followers. And you can't deny the fact that in her Facebook post, she identifies the fact that she is a trustee. So for those reasons, I found the Facebook post linked to her conduct as a trustee. Secondly, she made certain comments on the Facebook post that you can't get around that I found concerning. And finally, the comment about the detention center was inappropriate for the reasons I've set out in my report. And I stand by those findings. And I think more importantly, I think Trustee Blackburn recognized that those comments were concerning. What's important is Trustee Blackburn, from my evidence or from the evidence of her credibility and my assessment, was not out there to target SL, but was more looking at simply policing from her home people that she felt were in violation of the rules regarding the COVID pandemic. I think it's also important to note, and I did recognize this in my report, that the rules and regulations regarding what would be open, what would be closed, and the changes were changing or fluctuating from day to day. And I think it's extremely important for everyone to recognize that although SL may have been in a technical breach of a rule regarding the use of the park facilities, that rule came out that day. Most average people in the community would not be aware of such changes on such a rapid basis, because these changes that we were being provided to from both the provincial government, cities, and the federal government were fluctuating on a day-to-day basis. So I do take into consideration that he may have been breaching rules, but I do not think those breach of those rules were so severe that they would warrant a comment that I think was inappropriate. So that was the mandate by which I followed. I made sure I followed the rules of the Code of Conduct in terms of procedural fairness. I made sure that Trustee Blackburn was well aware of the allegations. I gave her a chance to give me her side of the story. The benefit of her side of the story was she did provide a media release that effectively matched what she was telling me. That media release, rather than debating whether it was her version or not, it seemed to be a version. It matched what she told me. I incorporated that into the report. And again, that media release does have adverse admissions against her interest. So subject to those comments, that was the basis by which I did the investigation. In the end, I'm aware that there's much publicity based on this. I was aware that there's, of course, since the investigation started, there have been numerous protests with respect to the anti-Black racism in Ottawa and throughout the province and throughout the country. And I wanted to make sure that this report was not going to be dictated by media and dictated by public pressure. I wanted to focus simply on the evidence that I had, rather than look at the fact that we are in a world where everybody is starting to, and I excuse the term, be woke to this issue that we should all have been aware of for many years in any event. But in any event, I was not guided by what we were watching in the media and what we were watching in terms of the protests. I was dealing with it strictly from the basis of the evidence that I had as to what transpired at that park. So subject to any questions, that's the manner in which I proceeded to do the investigation. I expect there should be questions, and I'm very happy to respond and answer those questions.
Thank you very much, Mr. Lakhani. It is now indeed our opportunity to ask brief questions of clarification on the report. I note that neither the questions nor the answers can contain any new information or expressions of opinion that go beyond what we have received in the report itself. We will have ample opportunity to express our views in our debate yet to come under items 4.1 and 4.2 our agenda. So I would ask that trustees restrict themselves to questions of clarification only. And I have several people on my list, beginning with Trustee Ellis.
I'm blown away at what a sham this whole process is, from the beginning to the end.
Trustee Ellis, would
And
you
so
ask
I
the
am-
question?
I'm recusing myself, and in fact, I'm leaving this meeting. There's serious racism issues here, and we're being precluded from discussing them. This is just a sham. Goodbye.
Trustee Ellis has left the meeting. Trustee Bell, you have a question?
I have a motion that I would like to put on the table, which is calling for the rules of committee. A vote.
I'm willing to entertain a motion for rules of committee. Is there a seconder for that? Trustee Campbell, did you put your hand up to second that? You did, thank you. So on the motion to adopt rules of committee, I will call the question. All those in favor of adopting rules of committee? And those opposed? And that motion is carried. So that means that you have 3 minutes, Trustee Bell, on this, but you still, and people may speak more than once.
Great, thank you. My first question is regarding what is the difference between racially insensitive on page 13 and how does it differ from an act of racism, whether that act is conscious or unconscious?
Was there any reference to an act of racism in the report?
No, there is this direct reference to racially insensitive, and I'd like a clarification on what is the difference between racially insensitive and an act of racism, whether it be conscious or unconscious.
I think what you want is to understand what the investigator meant by racial insensitivity. Mr. Lacani?
Well, there was two things that stood out for me in this investigation. One was I did not have evidence, or the evidence seems to suggest that her targeting of SL was not a targeting. There was no, I need to go and find, I was going to deal with SL because I believe as a Black person, he needs to be treated differently or treated in an adverse way. What I did find, however, was in the context of her discussion with SL, she made comments that were inappropriate and would meet the definition of being racially insensitive without, and I know intent is irrelevant. So regardless of the intent, the comments that she made and the picture that she posted were inappropriate from a racialized perspective. Two things stood out for me. There was one, the comment about obviously the detention center and making a reference such as that. That's when she tried to explain it as, well, it's a slippery slope and rule followers end up there, was without a doubt telling a young Black person for not following a rule that this is a possible destination is racially insensitive because it's a failure to recognize what most people recognize, which is the fact that there's an overrepresentation of individuals of the Black community in the jail systems and the criminal systems. She wasn't targeting SL, but in the discussion with SL, she crossed the line into making comments that were clearly racially unaware. It was tone deaf, for lack of a better word, in terms of the comment. The other issue that I had a concern with in terms of being inappropriate was most people followed. It seems that when she expressed to people the park was closed, leave, the evidence seems to suggest, assessing her credibility, that people would adhere to it. In fact, the comments that she made to the two young Muslim boys who were apparently using the park at the same time that SL was there and then contacting the imam was very clear that they adhered to her request. When SL did not adhere to the request, out of frustration, she then posted his image. The problem with
Mr. Lacani, I'm going to interrupt you there because the question was what you meant by racial insensitivity.
Right. So I think racial insensitivity is you're making comments and you're acting in a way where you're inadvertently being unaware of the effect and consequences of your comments directed to someone's race versus specifically acting in a way to discriminate against someone, which is what I would feel would be racially discriminatory behavior. That's the long and short of it.
Thank you, Mr. Lacani.
Trustee
Bell?
The next question. I am curious why further investigation into the credibility of SL through third parties was not looked into.
It was 100% my requirement when I meet with parties to an investigation, not just this investigation, any investigation, where I advise them when I meet with a party, a party to me is the complainant and the respondent. I make it very clear to both parties, please let me know who you think I should meet with and why. Give me the rationale so I can meet with them. SL's statement did not provide me with that information. My follow-up letter through his lawyer, where I asked for clarification, explicitly set out, please give me the names of people you think I should meet with respect to your version of events. I received nothing into that comment. With respect to Trustee Blackburn, she provided me her evidence and provided me the names of witnesses, not just simply the two witnesses she called, but other witnesses in the community that she felt were relevant. I gave SL the exact same opportunity. He did not avail himself of that, unfortunately.
Trustee Bell, anything further?
Yes. Why weren't previously racially insensitive comments made by Donna Blackburn not taken into account during this investigation? And subsequently, why was her good
Trustee
deeds taken
Bell.
into account?
Trustee Bell, I will interrupt you on that because the only thing that we are considering here is what is in the report with respect to this particular incident.
So I'm asking for clarification of why that was not taken into account in the report.
The parameters of the report are defined by the parameters of our code of conduct policy, which is that the only thing that we are considering here is the investigator's report. He was bound by that to confine himself to the specific incident.
Then my last question is, why was SL the only person singled out in the picture, but not singled out according to the investigation?
And I think that's a question that cannot be answered by the investigator unless he was given a reason by Trustee Blackburn or and I guess it would have to have been from Trustee Blackburn. Mr. Lacani, did you have such a reason?
Yeah, I think the one main reason why only his picture was there, and Trustee Blackbird's evidence was quite clear on this, he was the one who did not listen to her request to vacate the park. That was all it was. Everybody else did, so there's no need to post her pictures. It was as simple as that. I'm not sure what would have happened. I would have been speculating if the two Muslim boys did not leave the park, but they left.
Trustee Bell, is there anything further?
Lots, but I'll hold off. Thank you.
Thank you. I have Trustee Penny next.
Thank you, Madam Chair. I have no questions. Sorry I put my hand down.
Okay, in that case, I go next to Trustee Campbell and then Trustee Fisher and then Trustee Huff and then Trustee Schwartz. So Trustee Campbell.
There you go. Can you hear me?
Yes, we can.
First of all, Mr. Lacani, thank you very much for your report and actually for the oral gloss you just now provided, because you've actually satisfied a number of my questions. I do have a few remaining though. In actual, not intentionally, but as it happens, I guess my first is effectively in some follow-up to some of the previous questions asked. Was it made clear, or should it have been clear, I guess, to SL or their legal representative that a failure to meet in person might impact upon determinations of credibility? That's my first question.
Well, it's a very good question. I can tell you that SL having retained counsel would obviously be entitled and be privy to being provided with very good counsel. It's not my job to be his lawyer, it's his lawyer's job to be his lawyer. In a way, it actually helped in terms of this investigation, because any lack of finding a proper, assessing his credibility and being compromised by the fact that I was unable to meet with him was very clear in my correspondence, because my correspondence to SL and his lawyer was my preference completely. It was always to meet with SL virtually so I can see him and talk to him. I did not know he had counsel. I think this is important as well. I did not know he had counsel immediately. So when I was retained to do this investigation, my initial request to SL was channeled through his father, Mr. Kedro. So it was channeled through the father, and I made it very clear that I want to meet with SL. The father can be present as long as, or a family member for support, and I wanted to get the version of story. I received crickets to that request, and the reason I probably got crickets to that request was because they had met with Mr. Greenspan and retained counsel. When Mr. Greenspan had been retained, my correspondence to Mr. Greenspan was very simple. I would love to meet with SL in person. I would like to talk to him and get his version of events. I was told that I was only going to get the statement. At that point, they had made the decision that they were not going to meet with me in person. They were only going to deal with me through a statement. In terms of whether that would compromise the credibility assessment or not, I'm 100% sure that SL's lawyer was well aware and should be well aware.
Mr. Lacani, you're offering an opinion.
Okay, yeah. So because he had counsel, I was comfortable in the fact that counsel would provide him with the proper evidence or opinion on things. So I relied on his counsel.
Thank you. Trustee Campbell?
Thank you very much. That's great. And actually, listen to the discussion. I think at this stage, really only have one more question.
Sure.
And that is, I can't give you the paragraph, but I have the page reference. It's in page 10. You refer to some explanations provided by the trustee, and maybe paraphrasing a bit here, for their conduct seem to you to be disingenuous. But I didn't see in the report reasons why you formed that belief, or which descriptions of conduct that view applied to, because you indicate some. So presumably that belief or view of yours applied to some, but not all. And so I just like perhaps clarification is how you came to that, and what you meant it to apply to. And that's my last question.
Yeah, I think it makes perfect sense.
And I'll ask if you can do it without including additional opinion.
Perfect. Two main conclusions that I reached were not based on her version as to what she believed was her explanation as to what they were based on, and I've indicated what her version of her explanation was. One was the in this detention center comment. In her explanation, it was not to be racially insensitive. It was simply to show she recognized it after the fact, but during the investigation and during my and her evidence was I was simply trying to show SL that by not following rules, there's a slippery slope. I found that explanation to be, it didn't hold water to me, because I believed that comment was inappropriate, and I made that conclusion. The fact that she got there on her own is irrelevant, but her explanation was it was a slippery slope. That's all I was trying to imply. To me, it was wrong regardless of her explanation. The second one was I posted his picture because I just wanted to show that he was not, he was the one who was not following rules, and I wanted to show the community that I was there for the community safety. My concern with that was the picture itself was inappropriate. I did not buy that story. I found it very concerning to have his picture posted. I had a concern with the fact that she was well aware of the fact that he was a young person. I referenced the fact that she referred to him as a kid several times in that post. So she was well aware he was a young person, and that she took a picture of a young person who was a Black individual and identified him as someone who was not following the rules. That was my version as to what I think I found versus her explanation.
Great, thank you.
Thank you, Trustee Campbell. I have Trustee Fisher next.
Well, thank you, Chair. I was just trying to turn on my video. Mr. Lakhani, I want to thank you for the report and the time that you've taken to gather the facts and to present them to the board tonight. I guess the two quick questions that I have for you, the first one being on page 7 of your report, you indicated that Trustee Blackburn had initiated legal action by way of a notice of libel against Mr. Kudrow. Do you feel in any way that that created a cooling effect and impacted your ability to gather the facts and to build a rapport and a relationship with the family?
Trustee Fisher, that's asking for an opinion. I think we have to go with as much as is already in the report.
Okay. The second question I have is on page 18, I believe. You mentioned that Trustee Blackburn had initiated sensitivity training. Was there any proof of that provided to you in the course of your investigation?
It was simply her evidence that she did such training. It was conveyed to me. I found her to be credible based on that. It was conveyed to me through her counsel as well. So based on my assessment of credibility, the fact that it was conveyed through her counsel, I had no reason to dispute that at that point. So no, I didn't ask for confirmation. I accepted the fact that it was credible and it was presented through her counsel as well.
Okay, thank you. And thank you again for your report.
Thank you.
Thank you, Trustee Fisher. Trustee Huff, I have you next.
Thank you, Mr. Lakhani, for joining us this evening. I'd like to circle back to a comment that was made by Trustee Bell. I'm not sure that the response that we got actually answered the question, and that was pertaining to the issue of credibility for SL. Given that you assumed that he was getting legal advice that steered his direction toward providing a written statement as opposed to a in-person or online interview, was there any attempt to verify his credibility in that Trustee Blackburn had two witnesses who she had actually communicated with during the event. SL did not have anyone in that same framework to turn to. So was there any effort made to contact a character witness to establish his credibility as a young person, a teacher or a neighbor perhaps? Was there any attempt to find out whether this young man would be a truthful person to speak to?
I have two thoughts on that. I have generally in investigations a concern with character evidence generally. That's because at many events, people can always find somebody that will say they're the greatest things in sliced bread. That's one of my beliefs on doing an investigation relying on character evidence. I'm more concerned with relevant evidence. What I can tell you was, as I expressed to in one of the previous questions, I made it very clear in my review of the statement and my follow-up response back to their lawyer and to SL, or to SL through his lawyer. Please provide me with who you think is relevant. I gave them the opportunity to avail themselves of that option. Number three, I guess, what was really important was the main witnesses that Trustee Blackburn and SL all confirmed as being present were the two young Muslim boys. I couldn't get to them, but I spoke to the imam that had a direct conversation with those two boys. There was for lack of a better word, a lot of the evidence of SL and a lot of the evidence of Trustee Blackburn lined up. And when evidence lines up and matches, there's no need for me to meet with external witnesses to confirm what both parties are both admitting to. And much of their evidence did line up. In fact, it was very minor factors that did not line up. And those two factors I was not able to make a conclusion on in terms of the allegations of the threatening comments about tripping on stage, for example, and the interfering with the graduation. But the fact is, they lined up on terms of the call of the basketball coach. They lined up in terms of the two young boys at the park. They lined up in terms of the comment about the detention center. And there was no denying what was posted on the Facebook page. So much of this evidence was clearly available and corroborated between the two parties. I didn't need external witnesses to assess what I'd already learned.
Trustee Huff.
Very well. I just did want to point out, though, that the interpretation of please provide me the names of people who I should speak to could well be interpreted as being in reference to people who could speak to the particulars of the incident as they happened, as opposed to his character. So that was the only point that I wanted to make there. Thank you for the clarification about the overlap of the versions of the story.
Thank you, Trustee Huff. Trustee Schwartz.
Thank you very much, Madam Chair, and thank you very much, Mr. Lakhani, for both the thorough report and for joining us this evening. My questions really do pertain to the factual report, and I just want some clarification on a couple key points that I identified. In SL's testimony, or in the reply that you received, there was an indication that personal privacy and that he felt his personal privacy was breached. Furthermore, he also felt discriminated against, singled out, and he felt shamed. Is that an accurate depiction of what he provided?
Well, the unfortunate reality of that statement was it was in written form. It would have been of great benefit to me to have heard those statements in person and seen the reaction of the person expressing those statements. In fact, those exact words were what I asked for clarification from when I sent back to SL's counsel, or SL through his counsel, as to what I would like clarification on. And I brought up specifically those exact phraseology to find out, were those his own words, were those what, and some clarification on it. And all I received back was confirmation that those were his words. But again, words like that in terms of someone telling you that this is how it's impacted them is something where you would really much rather have met with them to see how it impacted them, which is an unfortunate situation in this matter, and that I wasn't able to do that despite efforts to do so.
And would you say, based on the factual report, that in fact privacy was breached?
I simply concluded that the posting of the image without of a young person, identified the fact that he was a young man. She identified him as a young man, was in itself the wrong thing to do. There's no doubt about it. And I think she acknowledges that too. Whether she blatantly acknowledges it or not is irrelevant. The fact is it was wrong, and there is an acknowledgement it was wrong.
And do you believe, based on the evidence, that that in fact SL was discriminated against?
I don't believe, based on the evidence, that he was targeted or singled out based on his race, but I think the comments and the actions that were directed to him would meet the definition of racial insensitivity.
Thank you. And my next question is in reference to, on page 10, in your findings or related to credibility, you do indicate that you do find some of her explanations related to her conduct to be disingenuous. Can you please comment further on that point?
It was what I explained to the previous trustee. I think I stand by those answers. I think her explanation as to why she mentioned in this detention center. Can you hear me? My internet seems to be going in and out. You guys can hear me okay? Okay.
Yes.
Okay. So the issue of the slippery slope comment, and I was just simply trying to convey to him that those individuals who do not follow rules, there's a slippery slope to one day perhaps being in a detention center. That was her explanation. I didn't buy that explanation. I believe the comment was, for lack of a better word, in itself is a problem. I think the posting of the image of simply to show her community, you know, I'm here to make sure the community is safe and I care about the community, and I wasn't trying to embarrass him, was as an explanation, and it was more about showing that she was concerned about her community and her I guess her role in the community. To me was not as concerning to me as simply posting an image of a young person and identifying him as a rule breaker, especially a young Black man, and identifying him as a rule breaker. Those are two theories that I reached that were not what she was presenting to me, but I think on her reflection, she acknowledges some of the concerns about those things that I identified as being a problem. So whether she had acknowledged them in the end or not, I would have reached the same conclusions. They were a problem.
And lastly, I'd like to just turn to page 13 in your report, where you actually, in the terms of the factual findings, you do actually refer to that it should be noted that the comment related to sort of racial insensitivity in particular has been acknowledged, but that you also indicated that this was made by an elected official with corresponding fiduciary responsibilities and obligations toward the public. Can you please comment about the importance of the fiduciary responsibility that under common law?
I think that's more of a legal opinion that probably your lawyer can explain, but what I was trying to simply convey there, which I think is important, was, and which the report tries to stress as much as possible, her conduct was not, as much as she may try to establish it in her evidence, I'm a concerned citizen worried about the pandemic. Her role as a trustee played a significant factor in how she approached it. I identify, I think if you look at my paragraph, if you look at page 11, where I talk about where I start with the bullet point, trustee Blackburn did not conduct herself only as a concerned citizen, but her role and status as a trustee played a significant part. And then I have the sub bullets. Those sub bullets to me are relevant to that issue. She was acting in the capacity of a trustee based on those bullets. The evidence supports it. And if you're an elected official acting in a way that is connected to you being an elected official, and that conduct is considered to be wrong, you're not wrong as a concerned citizen, you're wrong as an elected official. And I make the connection above. In terms of the fiduciary obligations, I think it's well established that elected officials are fiduciaries. I identified the court case that confirms it with respect to school trustees, but that is a given in our common law.
Okay, thank you very much.
Trustee Schwartz, I think you're out of time.
I'm good.
And I have no other speakers with questions on the investigator's report. So at this time, I would like to express appreciation to Mr. Lacani for attending here with us this evening and responding to our questions. And move on then to the next item on our agenda, which is item 4.1, report 20-043, Code of Conduct Breach Determination. Madam Director.
Thank you. And through you, Madam Chair, I'll call on Executive Officer Giroux to introduce this report.
Thank you, Madam Chair. Through you. You have the report in your package. I think you're all aware that the school district has a board member code of conduct policy. That policy establishes standards of practice for behavior for trustees. In April of this year, a complaint was filed with respect to the behavior of Trustee Blackburn, and specifically that Trustee Blackburn's behavior on March the 27th contravened sections 3.8, 3.15, and 3.18 of the board member code of conduct policy. A copy of the complaint was distributed to trustees. A third-party investigator was retained. The investigator's report has been presented to you, and this evening you had a chance to hear, to hear his presentation. When the board has a formal review under the code of conduct, and once it's received the investigator's report, it has a responsibility to make a decision as to whether or not there has been a breach of the code of conduct. And so that's the position you find yourself in this evening. Under section 430 of the policy, the board shall consider only the findings in the final report when voting on the decision. And that, of course, applies to the subsequent decision. So once the board determines whether or not there's been a breach of the code of conduct, the board may then make a decision about what sanctions, if any, shall be applied. And we have a separate report explaining that process once the board has considered this first issue. Except for the trustee who is alleged to have contravened the code, all members of the board may vote on decisions regarding the code of conduct unless any member has recused themselves. The trustee who filed the complaint is entitled to vote. Decisions made under the code of conduct policy require a vote of at least 2/3 of the trustees of the board elected or appointed to the board. That means that 8 members must vote for any motion to carry. In terms of other issues, I think the report is self-explanatory. I am happy to answer any questions before you deliberate on this. You'll see at the end of the report, there is a recommendation, and that recommendation allows you to insert whether there has or has not been a breach of the code, and any member may move that recommendation. Happy to answer any questions.
Thank you, Ms. Giroux. And I have several people on my list here, and I will go first to Trustee Boothby. Then I have Trustee Penny and Trustee Campbell. Trustee
Sorry.
Boothby.
Yes, sorry, Chair, and I apologize, but I can't put video on. I'm away from Ottawa on a personal matter, and I have very tenuous internet here, so I apologize for that. I would like to put the motion on the floor, Chair, and I'm just trying to scroll through and find it. So the recommendation that is on page 5, I would like to put that on the floor and insert has breached sections 3.8, 3.15, and 3.18 of the code. And I'd like to.
Thank you, Trustee Boothby. Before we proceed, I would appreciate us having a seconder. Does anyone wish to second that? Trustee Penny, would you like to second? Trustee Penny?
Yes, Madam Chair.
Thank you. Trustee Boothby, please proceed.
Okay, thank you, Chair. And I'd like to thank Mr. Lacani for their report. I think it was a very good investigation, and I appreciate all the points in the report. So section 3.8 talks about our trustees have to uphold the dignity of the office and conduct ourselves in a professional manner, especially when representing the board and attending any kind of board events. I think it's very clear from the investigative finding that Trustee Blackburn was acting as a trustee. Trustee is all over the Facebook account. The account that was subsequently removed talked about her having an additional role to being a trustee. So it's very clear that she was presenting herself as a trustee, and her behavior, as far as I see from the report, and I think the findings are clear, that she was not acting in a dignified manner. Section 3.15 talks about our requirement for civil behaviors, and we have to engage in conduct that not engage in conduct that would discredit or compromise the integrity of the board. As well, section 3.18 says board members shall at all times act with decorum and shall be respectful of board members, staff, students, and the public. So whether or not Trustee Blackburn was aware that SL was a student, he certainly was a member of the public. And the findings certainly point to the fact that she did not conduct herself with decorum, nor was she respectful to this young man. He felt by his own undertaking that she had shamed him. I would feel shamed if somebody put a post like that of me on Facebook. By her own admission, she felt that it was wrong and took it down later on. I think that supports that she understood that that was a shameful act. His privacy was violated, and the fact that he felt discriminated against. None of those can even be close to being called acting in decorum. So I would implore my fellow trustees to find this, that she certainly has breached all three of those parts of the code of conduct, and as such has brought considerable shame to the Board of Trustees and the OCDSB itself. That's my introduction, Chair.
Thank you, Trustee Boothby. I have Trustee Penny next on my list.
Thank you, Madam Chair. And thank you very much, everyone. I will be supporting the finding of breach because I've determined by reading the investigator's report and listening to the ensuing discussion that Trustee Blackburn did not uphold the dignity of office. Indeed, she clearly diminished the role of trustee by questioning SL on March 27th over an hour by both admission and by threatening to follow him home by both people admitting it. She further discredited the board by her racially insensitive remarks that goes against everything that the OCDSB has been working for the past number of years. I think Trustee Blackburn is very aware of the things we've been trying to accomplish. She never really apologized to the youth publicly. In her public statement, she regrets only in the manner in which she delivered the admonishment and that she posted the youth's Facebook on her social media. She did not act with decorum and respect. Trustee Blackburn has always had the option to walk away, but instead she chose a different path. And to wrap it up, she could have apologized well before May 14th and well before seeking the advice of a lawyer. It doesn't take a lawyer to say you're sorry. And for those reasons, I am wholeheartedly supporting and also imploring my colleagues to find breach. Thank you.
Thank you, Trustee Penny. I have Trustee Campbell next and then Trustee Jenkins.
Thank you, Madam Chair. agree with the general drift of the sentiments and views expressed, but it may break the momentum here. I actually just have a little technical question, and that is in 431 of our Code of Conduct Procedures. It says that the resolution and the reasons for the decision shall be recorded in the minutes of the meeting. Does the board have to have agreed reasons, or can everybody have their own, variously expressed reasons, or do reasons per se, are they really needed or necessary in addition to the resolution itself?
On that, I will defer to the executive officer.
Madam Chair, I think that if we think about how the minutes are captured, trustees have an opportunity to express their rationale as they indicate, as they speak to the item, and that I believe suffices as the description of reasons, unless legal counsel feels differently. I don't think, based on our past experience, that we've detailed reasons in the motion itself, but rather just in the minutes.
Great, thank you. That's it for me.
Thank you, Trustee Campbell. Trustee Jennings. You're muted.
Thank you. Thank you, Chair Scott, and thank you to the Executive Officer Giroux for the preparation of the report. And I will be supporting this recommendation that Trustee Blackburn has breached sections 3.8, 3.15, and 3.18. And if you'll bear with me, I just prepared just a statement to why I'm voting that she has breached the sections. I just feel that our role is to promote student achievement and success, and this means nurturing the well-being of our students and their families and ensuring that children are given the opportunity to participate in all things to the best of their abilities. And equity in education is crucial and personal, and social circumstances such as gender, ethnic, origin, or family background should never be obstacles to achieving educational potential. As a school trustee, we must hold ourselves accountable for our conduct. Trustees are required to comply with the board's code of ethics or conduct, which sets standards that govern our ethical behavior in all circumstances. This includes the expectation to act with integrity, adhere to high ethical standards, and to conduct ourselves in a manner that enhances public confidence. The school board's current strategic plan has 3 priority pillars: culture of innovation, culture of caring, and culture of social responsibility. 2 of these are prudent in this situation. Culture of caring prioritizes the dignity and well-being of students and builds authentic engagement with our communities. Culture of social responsibility encourages responsible and ethical leadership and accountability. How do these responsibilities and our strategic plan relate to this incident? Trustee Blackburn learned that the young man at the basketball court is a high school athlete. She threatened to have him removed from his basketball team, and she threatened that he would never graduate. Trustee Blackburn also directly reprimanded the student by stating, "People like you end up in Innis." These actions do not promote student well-being, do not promote student success, and do not build trust and authentic engagement within our community, and do not show ethical leadership. I believe she must be held accountable for her actions in this instance, and her actions do not represent the spirit or pillars of the Ottawa-Carleton District School Board. There was no demonstration of integrity, no representation of ethical standards, and she damaged the public confidence in our school board. I believe we must abide by our principles and stand with our community to maintain the trust of our students and their families. Thank you for this opportunity to let me share my thoughts.
Thank you, Trustee Jennings. Next on my list, Trustee Bell, and then Trustee Schwartz. Trustee Bell.
Thank you, through you, Chair. Based on the facts that I have read, and from what I understand of what is racism, I'm going to call it out. And whether racism has occurred is not to be determined by those who abuse their power and act with prejudice against another because of their race, whether it was intentional or not. It is demonstrated through the impact of their actions on racialized person or a community. Donna Blackburn has abused her power in many instances, as demonstrated by the fact, and we must listen to the voices of those that have been impacted by our community. The case has resulted in trust being broken between the board and the Black community, and now it is our duty to build that trust back. I will be supporting this motion.
Thank you, Trustee Bell. Trustee Schwartz.
Thank you very much, Madam Chair. And I too wish to support the motion on the floor. Based on the investigator's report and the subsequent discussion with the investigator, I believe that Donna Blackburn did breach sections 3.8, 3.15, 3.18 of our Code of Conduct policy. She's demonstrated disregard for the office of trustee, and through her actions on March the 27th, demonstrated by the facts delivered in the report, she certainly has not upheld the dignity of the office. She must be held accountable, and we must stand with our community to rebuild trust that has been broken as a result. And it is our duty to also conduct ourselves with high ethical standards. As such, tonight, I do believe we're going to be dealing with the Code of Conduct investigation before us. And personally, I actually feel quite emotional. I feel sad and disappointed, but above all, I feel anger. I will not be referring to Donna this evening as Trustee Blackburn, but simply as Donna. I no longer believe she's deserving of the honorific trustee, because I believe that it is a sign of respect for the office she holds, and I no longer believe that that respect should be delivered. I will leave my comments at that.
Thank you, Trustee Schwartz. Trustee Huff.
Thank you, Trustee Schwartz, for opening the emotional door, because that's where I was headed. I feel that I will also be supporting this very sad moment to recognize such an act of inappropriate behavior from one of our own. I find it devastating. I have found the last few months unbearable with what we have gone through as trustees, as fellow trustees, the emails that we have received from the public that extend well beyond the Black community, calling us out for bad behavior, calling us racist, calling us everything under the sun because of behavior of one person on this board. I am angry that I am spending this evening of my life dealing with this. This is time I will never get back. I am at a loss as to how I will be able to rebuild the trust in the community that I've been elected to serve based on this. Not only your actions, Donna, but the process itself, the fact that we've had to wait so long and be silent and look like we didn't care. This has been completely unbearable. And I am almost without words. So I will end now, but I will be supporting this.
Thank you, Trustee Huff. Next, I have Student Trustee Widjawara.
Thank you, Chair. Likely in what will be the last speech I'll have the opportunity to make to the Board of the Trustees. I would just like to thank everyone at the table and everyone involved in the process for their professionality and the level of leadership that was demonstrated throughout the process. And I say this not just as a student trustee, and I think I say it also as a sentiment on behalf of all students, as well as a person of color living very close to where the incident had occurred. This decision that trustees will make today will have a significant impact on how students look to student trustees as well as superintendents and trustees in the future for collection of student voice and any other professional matters. In brief, emotions can run high in such instances, but I would honestly like to thank the professionalism, transparency, and level of morality that the board has demonstrated throughout the process. Thank you very much.
Thank you, student trustee Widjawara. We are still in rules of committee. Trustee Huff, your hand is still up. Did you wish to speak a second time? And trustee, if not, then I'll go back to trustee Schwartz as a second time speaker.
Thank you, Madam Chair. I'm just wondering if we could, I do believe that there's some legal opinion that is being sought. And I'm wondering if it's possible for us to move into in-camera for a short period so we can actually speak with counsel privately.
In order to go in camera, we would need to have a motion to resolve in camera.
Okay, I'll wait till after vote, and I would then like to move forward with a motion to resolve into in camera, please.
Thank you very much for that. And I note that we are still in rules of committee. We can leave rules of committee and return to rules of committee depending on trustee motions, but at the moment we are still in committee and we are still on this particular item. I have only trustee Campbell then as another second time speaker. Trustee Campbell.
I don't know if it's needed or not, but move to rise from committee.
And we don't need a seconder to rise to return to board rules. So I will call the question then on trustee Campbell's motion to return to regular board rules. All those in favor? And I see that motion, I think, is carried. We have a lot of hands in favor. Is there anyone who is opposed? And the motion is carried. So we are now back in rules of board. And we do still have a motion on the floor, which was moved by trustee Boothby. We have not concluded our debate on that, but I will ask at this time if there are any further speakers on the motion in terms of people, particularly anyone who hasn't spoken. Trustee Boothby, I see your hand is up. Was that for wrap up?
Yes, Chair.
And before we go to wrap up, I would like to ask Trustee Penny if he would take the chair for a moment, please.
Thank you, Madam Chair. And Trustee Scott, did you have a question or a comment?
Thank you, Mr. Chair. I did wish to speak on this, to say that it saddens me greatly that we're called on tonight to make a decision on whether this behavior we've heard about this evening breached our board member code of conduct. In her time on the board, I would like to note that Trustee Blackburn has repeatedly made significant efforts to support many of our students who come from marginalized groups, and I recognize and appreciate her achievements in this regard. However, her treatment of SL on the 27th of March and in her subsequent media posts is deeply disturbing to me. An ordinary person might simply have informed SL that there were new rules about park use that had just come into effect. But the incident in March went much further than that. And in that incident, I believe that trustee Blackburn did use her connections as a board member, her authority as a board member, to attempt to enforce a different behavior by SL. Her language and her threats were intimidating and racially insensitive. Under our code of conduct, trustees are expected to conduct themselves in a professional manner, and that should include respecting the rules around posting photos of students who may be minors without proper permission, especially when the photo is accompanied with the words, "See why you elected me trustee." Secondly, coming from a member of a board who supported a strategic plan with a significant emphasis on taking actions to address inequities and concerns about racism, the insensitivity of trustee Blackburn's remarks have discredited and compromised the integrity of the board in the eyes of the community, and particularly the Black community, and have damaged the collaborative relationships that we've been attempting to build. And finally, the behavior that occurred. I think the only way I can describe some of it is bullying, and that extended over an hour, over the best part of an hour, and then subsequently was showcased in social media posts. To me, that is a blatant lack of respect towards another individual. And therefore, I do believe that sections 3.8, 3.15, and 3.18 of our code of conduct have been breached, and I will be supporting the motion with, as I said before, considerable regret. Thank you.
Thank you very much. And back to you, trustee Scott.
Thank you. So I have no other speakers, and we'll go back then to trustee Boothby for wrap up on this.
Thank you, Chair. And I agree, indeed, tonight is a very sad night that we've had to come to this meeting, and this is the subject of the meeting. Our position as trustees requires us to have and instill public confidence, such that the public feels that we can make decisions that are in the best interest of all the children in our schools. And we have been working very hard over the past few years to make all of our students feel valued and cared for. In this single engagement with a young man, trustee Blackburn, who admits to it, has set the confidence and the associated work that we have done back significantly. We need to send a very clear message to our whole OCDSB community that this is not a condoned nor tolerated behavior, and just sort of saying sorry certainly is not good enough. She needs to be held accountable for her actions. And I'd also like to make sure that we don't forget tonight the impact of her very insensitive actions on SL, a member of our community. Thank you.
Thank you, trustee Boothby. I will remind trustees that under the provisions of our code of conduct policy, it requires 2/3 of board members, which would be 8 trustees, in order to approve any recommendation. This will be a recorded vote, and I will invite our manager of board services, Ms. Giroux, to call the roll, please.
I think Ms. Guthrie will call the roll. It's way better.
Oh, Ms. Guthrie, sorry.
Trustee Boothby.
Boothby in favor.
Trustee Huff.
In favor.
Trustee Campbell.
In favor.
Trustee Janikins.
In favor.
Trustee Penny.
In favor.
Trustee Lyra.
Abstaining.
Trustee Bell.
In favor.
Trustee Fisher.
In favor.
Trustee Schwartz,
Schwartz in favor.
and Trustee Scott.
In favor. And is there anyone opposed in that? I believe, Manager Guthrie, could you just give us the count then, please?
All in favor, one
How many?
abstention.
How
8.
many? 8. 8 in favor, 1 abstention.
Correct.
Thank you very much for that. And moving on then to the request to move in camera. Would you like to make that motion, Trustee Schwartz? You're muted.
I would like to move
To resolve in camera.
Resolve into camera, yes.
And is there a seconder for that? Trustee Jenkins will second that. So I will call the question on the motion to resolve in camera. All those in favor? And those who are opposed? And the motion is carried. So just as a note to those who are watching on live stream, the live stream will not be available until we return from our in-camera session, and we will try to do that as quickly as we can. So I would appreciate if someone could let me know when we are off the live stream, and whether any of those who are currently shown as present in this meeting should be excluded from the in-camera session.
Maybe Manager
Chair
Owens can just
Scott.
explain the process.
I beg your pardon?
Maybe Manager Owens or Manager Guthrie could explain the process.
I believe it would be easier if we had a separate Zoom link for the in-camera session so that we don't have to interrupt the live stream. If we shut off the live stream, then we have to send out a new link to our viewers.
So what does that mean then in terms of what we need to do?
Manager Guthrie, do you want to explain?
I have just sent you all an additional Zoom meeting invite for the in-camera session, trustees and senior staff. What will happen is you can use that one. I will start that particular meeting. And then when we resolve into public, you will use the meeting link that Sandy provided you last week, again, to re-enter the public session.
So we leave this meeting, we accept the new invitation and join the other meeting, and then we return to this meeting with the original invitation. Thank you. I'm just checking to see whether everybody is back.
I think we're good, Madam Chair.
Thank you. Thank you, Vice Chair Penny. So I would like to call public meeting back to order and ask the Vice Chair of the board to provide a report from board in camera.
Thank you very much, Madam Chair. The board met in camera to seek legal advice on a matter, and we have nothing to report.
And thank you for that. And could you clarify that the legal advice was specifically on the subject of the responsibility of those trustees who will be participating in the code of conduct matter this evening, as to some of their to answer some of their questions?
That is correct. There was some questions regarding the participation.
You don't have to tell us what the questions were, but simply to confirm that it was confined, the discussion was confined to those matters.
That's right. It was confined to legal advice as per our in-camera direction that we can discuss things in camera.
Thank you very much, Trustee Penny. Moving on then, I see Trustee Lyra, your hand is up.
Yes. Could somebody please read from the chat? My internet is awful.
And I see that because the audio is breaking up, you have sent us a message on chat with the request that it be read. The message from Lyra Evans to everyone states, "I apologize for not being able to speak out loud. My internet is too choppy. I am recusing myself from 4.2. Thank you, Trustee Lyra. Moving on then, the next item on our agenda is actually item 4.2. And so I'd like to invite the director to begin.
Madam Chair, I'm happy to give you the overview. I'm just checking, Trustee Campbell, I think, is looking to access the meeting, and can someone please confirm that he's not in the waiting room or resend him the link?
I've sent him the link.
Okay. So sorry. Let me pull up my report here.
Madam Chair, would you like me to proceed or would you like me to wait until Trustee Campbell joins us?
If we can take a moment, I think, please, to get him connected.
In the interim, Madam Chair, I just want to clarify the count on the vote with respect to the breach was 9 in favor and 1 abstention. I think that we summarized it as 8, but when you look at the record sheet, it's 9 in favor.
Thank you very much. So it was 9 in favor and 1 abstention. So it carried either way. And are we having any success connecting Trustee Campbell?
We have sent him the link a couple of ways.
He just joined.
Thank you very much for that. So, Madam Director, would you please proceed?
Thank you, and through you, Madam Chair. We are at section 4.2 in our agenda, and we do have a report here regarding possible application of sanctions, and Executive Officer Giroux will walk us through and is prepared with to respond to questions pertaining to this particular report.
Thank you, Madam Director, and through you, Madam Chair. The board has now made a decision that there has been a breach of the Code of Conduct, and the next decision before the board is whether sanctions, if any, should be applied. And so the board is not required to apply a sanction. The code provides that no sanction shall be imposed where the board decides the trustee took all reasonable measures to prevent the breach, or the contravention was trivial or committed through inadvertence, or an error of judgment was made in good faith. Should the board decide to apply sanctions, the sanctions available to the policy are the censure of a member of the board, barring a board member from attending all or part of the board or a meeting of the board or a meeting of the committee of the board, or barring the board member from sitting on one or more committees of the board for the period of time specified by the board, which under our policy is not to exceed 6 months. The board cannot impose a sanction that is more onerous than any of these above. It can impose a sanction that is less onerous, such as a warning. The board has no power to declare the seat of a trustee vacant. So just a clarification about those three types of censure. A censure is a public expression of disapproval. The board has some discretion in terms of the severity of language that is used in a motion to censure, and that goes from the principle that a warning is less onerous than a censure generally being a strong statement which draws on the language of the code. In terms of barring attendance at all or part of a meeting, the board may bar a trustee from attendance at a specified meeting of the board or a specified committee of the board. We understand that that sanction could apply to a board meeting or any committee of the board meeting or any committee of the whole or committee of the whole budget meeting. But the use of the term a meeting implies that the barring is from a single meeting only. That's different from the provision with respect to banning from committees. The board may bar a trustee from sitting on one or more committees of the board for a specified period of time. This sanction can be applied to any board standing, ad hoc, advisory, or special purpose committee. The board can name those committees, any one or any combination of, and the duration of this sanction is determined by the board, and it's not to exceed 6 months. In terms of the participation in the decision-making process, the same rules apply to sanction as apply to the determination of breach. And as a result, the same voting rules that apply. So at least 2/3 of the trustees of the board elected or appointed must be in favor in order for a motion to carry. I think before you move to sanctions, you should be aware that there is an appeal mechanism under the policy where a member is deemed to have breached the code. The member is entitled to notice, and there is an established appeal process. And so following this meeting, the member will be advised that there was a breach, and will also be advised of any sanctions, should any sanctions be applied. And the member will also be advised of the dates of the appeal period, and the member has 14 days to respond to that, and the board must have a meeting within 14 days. So I provide you with that information so you're aware of what some of the next steps are in the process. I'm happy to answer any questions or bring any clarification to any of these issues.
Thank you, Ms. Giroux. I have several hands up. I'd like to begin with Trustee Penny.
Thank you very much, Madam Chair. And in preparation for this meeting, just in case we had a finding of breach, I thought that preparation was probably necessary. So I prepared a motion to go forward dealing with the question of sanctions, and I did forward it to Manager Guthrie, and I'd like for her to put it on the screen if we could, and also to distribute it by whatever method is necessary to the rest of the trustees so that they can see it. So I'm moving a set of sanctions.
Madam Chair, Manager Guthrie will share it on the screen. We will also email it to trustees, and in just a minute, we will update the link in the agenda so that the motion is added to the agenda, and members of the public who are watching this meeting can access it there. It may be easier to read that way than on the shared screen.
Thank you,
Madam
Mr.
Chair?
Rue. I believe that people will have to refresh their screens if they're following from the board website once it has been added into eScribe. And if you are working, if for trustees who are using eScribe to access the agenda materials, you will probably need to log out of eScribe and log back in again so that the information in your eScribe can update.
Madam Chair,
Yes.
I want to be in order or not. I'm actually not quite sure to suggest a 5-minute recess so folks can familiarize themselves with this.
I would like to see if the motion is seconded first, and then I would be happy to call for a 5-minute recess. So let's get the motion actually put on the floor, and then we will accede to your request so that people have a chance to read it properly and give it a little bit of thought before we proceed with the full introduction.
Okay,
So,
so I'm just gonna.
Trustee Penny is moving this. Are you going to read it, Trustee Penny?
I think that I probably should, Madam Chair. It is a little bit lengthy, but I'll read as fast as I can. And so that in accordance with section 437A of policy P073 the board censured Trustee Black for behavior which was disrespectful to individuals directly involved, disrespectful to the Black community as a whole, and which used language which is known to be offensive and more specifically is a form of anti-Black racism. And further, that the board condemned the behavior of Trustee Blackburn, which is not representative of the values and belief of the Board of Trustees, and that the board stand with the community in strongly recommending that Trustee Blackburn immediately offer her resignation from the office of the OCDSB Trustee Zone 3, Barrhaven, Knoxville, Maryvale. Part B, that in accordance with sections 437B and 439 of policy P073 Trustee Blackburn be barred from attending the board meeting at which the board will consider the approval of the 2020-21 annual budget. Part C, that in accordance with section 437C of policy P073 Trustee Blackburn be barred from sitting in the following committees of the board for a 6-month period, July 1st, 2020 and December 31st, 2020. Committee of the Whole Budget, Parent Involvement Committee, Audit Committee, any advisory committee designated under section 95C of the OCDSB bylaws, appeals hearing panels, expulsion hearing panels, and any ad hoc committees established by the board. And further, Part D, that in accordance with section 438 of policy P073 that the board encourage Trustee Blackburn to immediately undertake and complete anti-racism program to be recommended by the board's Human Rights and Equity Advisor. And Part E, that in accordance with section 438 of policy P073 the board encourage Trustee Blackburn to immediately undertake and complete a review of the Good Governance for School Boards Trustee Professional Development Program and provide a copy of the certificate of completion to the board. And finally, Part F, that the board refrain from appointing Trustee Blackburn to any representative position or role on behalf of the board for a period of 6 months from July 1st, 2020 to December 31st, 2020. And thank you very much, Madam Chair.
Thank you, Trustee Penny. Is there a seconder for this motion? I see your hand is up, Trustee Schwartz. Trustee Schwartz, are you seconding the
Yes,
recommendation?
Yes, I'm seconding.
Thank you. And so with that, then I will declare a 5-minute recess, and I really mean 5 minutes, so that everyone has an opportunity to read the recommendation or find it on the website or find it in their e-scribe. And when we come back, it will be Trustee Penny's opportunity then to introduce his motion, and we will begin our debate. So the board is in recess for 5 minutes. At this time, I'd like to ask trustees please to return to the meeting. And Trustee Penny, would you like to make your introduction for the motion?
Yes, Madam Chair, I'm not going to take too long. I just wanted to, having read the investigative report of the weekend and listened to the discussion tonight, I felt that, some manner of sanctions may be required should a finding a breach be rendered by the board, and in this case it has. So in that respect, I prepared a multi-part motion that is appropriate for the nature and the impact of the breach upon not only the effect upon the individual and his family, but also the reputation of board and the damage to the work that we are trying to accomplish and have been for many years. Divided up the motion into a few parts so that allow board to consider each sanction individually upon its own merit and the appropriateness to the breach. So an additional consideration with regards to the depth of the proposed sanctions is that Trustee Blackburn has previously also been found in breach of the code. Therefore, in my view, a more progressive approach to sanctions is required. And I would urge that my fellow trustees pass all the sanctions that's presented here tonight. And with that, I'll leave it to the discussion. And thank you very much, Madam Chair.
Thank you, Trustee Penny. I remind trustees that we are in board. We're speaking once to the motion. You will have up to 5 minutes for your comments. The motion is on the floor. It is amendable, but I would ask that trustees be very clear in their amendment language if there are any amendments to be proposed. In terms of amendments that would remove any section of the motion that has been put, those would, I think, be out of order because the same thing could be accomplished simply by asking to have the parts voted on separately and then voting against one or more parts of the motion if so desired. So with that, I will move on to Trustee Schwartz, who is next on my list, and then Trustee Boothby. Trustee Schwartz.
Thank you, Madam Chair. And I would ask that we actually move to committee rules, please, for this portion of the debate.
Is there a seconder for adopting rules of committee? Trustee Campbell, are you willing to, Trustee Huff, are you willing to second that? Or Trustee Campbell, are you willing to second that? I'm seeing hands flicking in and out here to adopt rules of committee. Trustee Campbell?
Trustee Fisher will do it.
Trustee Fisher will second that. I will call the question then on adopting rules of committee. All those in favor? And those who are opposed? And the motion is carried. So Trustee Schwartz, please go ahead. And you have now 3 minutes.
Thank you very much, Madam Chair. I support the motion in front of us tonight, though I look forward to the debate and I anticipate that we will be seeing a number of amendments in terms of potentially time frame and so forth. I did prepare a statement that I wish to read just onto the record this evening in anticipation that we might get to a point such as this, in which case, if we did find from the report that there was a breach, I decided I needed to make a public statement as well. So it's true that Donna certainly represented Barrhaven constituents and their interests for many years. She has privately raised funds for Syrian children attending schools in my community, and she's been a strong advocate for the OCDSB. I want to thank her for her commitment in public service. But her actions on March the 27th, and frankly, some of her previous behavior during board meetings have not been those of a community leader. They have in fact been that of a bully and of someone who has abused her privileged position as an elected official. As I stated previously, I feel angry. I'm angry that her deplorable actions on March the 27th have caused harm to a young Black man. I'm angry that the process has taken so long to be brought into the public domain for debate, and as a result that my voice was silenced for the past several months. I'm angry that I too, through association, have been characterized as a bully and a racist. I'm angry that the reputation of the OCDSB has been damaged by the acts of one renegade trustee. And I'm angry that the staff and trustees have had to focus on a code of conduct issue the very moment when our students needed us most. Back in January, when we held our board retreat, I left the weekend feeling hopeful that this board was working toward inclusive learning environments for all students. I felt excited about the future for OCDSB students and for our community. I knew that I was surrounded by staff and trustee colleagues who didn't just virtue signal, but who were truly committed to work toward equity and equality for all. We all acknowledged the harm done by systemic racism and bias and committed to taking action so that every student who comes through our doors has the opportunity to reach their highest potential. Donna's admitted to her actions on March the 27th toward a member of the OCDSB community. She bullied a child. She abused the power of her office. Her subsequent written statement, along with the investigators' report, signals something even deeper. They signal that she isn't remorseful for her actions because she doesn't really think she did anything wrong. It took her more than a month to issue a public statement of apology. It took her Facebook friends telling her the photos and the message she shamefully posted were problematic. This does not signal to me someone who deserves to hold public office, and therefore I agree with the sanctions in front of us. I would like to see stronger sanctions if possible. I have questions for our council to see if we can go further than the sanctions in front of us. But I wanted to say to all the staff, parents, students, and community members watching this evening, I simply want to say, I know we're better than this. This is a moment for the OCDSB to stand together and to put action behind our pretty words and policies of equity and inclusion, of anti-bullying and of anti-racism. The students in our board deserve nothing less. So my questions.
I think you're out of time.
If I'm out of time, I'll just be put back on the list for my questions, because I do think that we need to actually think about the seriousness of the allegations, as well as determine whether these sanctions actually meet the serious test. And I don't believe
we will get to that when you speak again. Trustee Campbell, or sorry, Trustee Boothby first, and then Trustee Campbell.
Thank you, Chair, and thank you to Trustee Schwartz for really doing a very nice job of summing up how I have felt over these last few months. This has been a terrible stain on OCDSB. We are not a group of people that carry out this kind of behavior. Trustee Blackburn is not a first-term trustee who doesn't understand what the role of a trustee is, or doesn't understand when she's overstepping what the role of a trustee is. This is her third term. So when we are asked to consider these sanctions, I think they are very just. I think Trustee Blackburn was well aware that her behavior was not in any way something that the rest of the board would condone. It has set us back, as I said before, in our work against anti-Black racism and other marginalized students in the board. And unfortunately, it has undone any of the work that she has done before, some of which has been on her own accord, much of which has been done as one of the trustees. But that has been significantly undone. In my opinion, your actions during that day were not thinking as a trustee or thinking even as a community member. but just hoping to promote yourself. And to use a child on Facebook and shame a child when you are responsible for 72,000 children is unthinkable. And the damage that has potentially been done to this child and the reputation of this board and the reputation of Ottawa as a caring community as a whole will have repercussions for months and months and months. So I too would like to hear what our lawyer has to say about if we can go further. I think that these are very well thought out sanctions, but I think between Trustee Boothby's or Trustee Blackburn's past and knowing full well, having this been her third term, that her behavior was absolutely unacceptable. It went on for an hour by your own admission. I would like to take the sanctions as far as we can possibly go.
Thank you, Trustee Boothby. Did you have a question there for council in terms of whether or not the sanctions that are included in the motion fall within the parameters expressed in the staff report?
Yes, and I'd also like to know, are there sanctions that we could go further?
Thank you. So Ms. Giroux and or Mr. Herndon.
I'll start. I think the, in the introduction, we described the form of sanction. So there's censure, there's barring from a meeting or barring from a committee. There isn't scope in the legislation to go further than that. The only possible area where I understand that you could go further is that this board has a policy provision restricting some sanctions to a 6-month period. That time restriction, I do not believe exists in the code, and legal counsel can confirm that. But that is your policy at this time, and you are to be governed by your policy at this time. So that's something you might consider in the future. I don't know if legal counsel has anything to add to that.
I confirm Ms. Giroux is correct that the 6-month limitation is something that the board included in the Code of Conduct. It isn't required by the Education Act. Having included in the Code of Conduct, you must adhere to it. In terms of whether any more severe sanctions can be imposed, the simple answer is no. The sanctions that are listed in the draft motion represent let's say, a fulsome interpretation of the authority under the Education Act. And in my judgment, or in my opinion, any sanction more severe would be outside the authority that you have under the Act.
Thank you for that. And Trustee Boothby, you were out of time, so I will move on to Trustee Campbell.
Thank you, Madam Chair. I guess a couple of questions, whoever feels they're best place to answer, and then I guess I didn't really have prepared a statement, but I'll maybe opine a little bit. It's a small little thing, but in terms of we have the word, I know it's straight from legislation, but in B we have attending the board meetings, and in C we have sitting on the following committees. So does attending mean that they may not participate? Not only that they may not participate, but they literally may not be in attendance? Or is there no real distinction between attending and sitting?
There is a minor question. Maybe with the chair's permission, I'll respond to that. Sorry.
Oh, sorry. So basically, there's a variation in wording between B and C. In B, it refers to being barred from attending, which is broader certainly than participating. And in C, it talks about being barred from sitting, which presumably implies participating. Now I know this wording is straight from legislation, but I guess my question is, should we actually see an equation of these two terms? This is a tiny little technical question, but should we see these terms as equal, or is actually indicating something different?
Mr. Herndon?
Yes, unless Ms. Giroux had clarification that she was going to provide. Trustee Campbell, that you've highlighted an important distinction between the two forms of sanction. You shouldn't merge those together. The sanction in B, which speaks to attending, is only associated with that particular form of sanction. So you bar the board member from attending a meeting, but note that it's confined to all or part of a single meeting. However, the barring the board member from sitting on one or more committees represents an authority to direct them to not be on the committees that they would otherwise ordinarily be appointed to.
Great, thank you for the distinction. That makes sense to me, and I think it's taken a unnatural tangent in my interpretation there. That's appreciated. In terms of F, I'm thinking, but I would like, I guess, verification or tell me I think he's wrong here, but that basically the refraining from appointing for a period of 6 months, that would, the effect of that clause for it to be in line with our policy would be to refrain from appointing to a role on behalf of the board for a period of 6 months, where that role, that time period for that role itself is defined by the same 6 months. Is that correct? Am I coming across in terms of my question?
Are you asking, Trustee Campbell, if it would be that we could only refrain, not appoint somebody for 6 months, or whether their appointment couldn't be prevented for more than the 6 months in terms of the duration of the appointment?
Their appointment that this sanction should be passed, whatever, would not preclude the trustee from being appointed to something on the expiry of the 6 month period. And that would be okay. I mean,
maybe I'll start, because part of this is our own procedural practice, and then council can advise on any legal issues. So every time you make an appointment as a board, you generally do that either by motion if there's only one person, or by way of ballot. And so this provision is barring from sitting on the current committee. It doesn't deal with future appointments, but presumably if you had an appointment for vacancy during the 6 month period, you wouldn't be appointing the member. If your question is, can you or will you be barred from appointing the trustee to a committee for a term that goes beyond that 6 month period, I think that we would need council to provide some clarity on that.
I guess if I may just insert, just to clarify myself, perhaps, my concern is that there'd be a limited interpretation here. If there's an expansive interpretation that could be seen as trying to reach beyond the 6 month period. And I guess that's my question.
And Trustee Campbell, that is clearly prohibited. The 6 month time frame would apply to the duration of any bar against a trustee from sitting on a committee.
Oops, there we go. Sorry for this, but just so I'm clear, as I interpret it, basically, if passed, it would the board would be enjoined to refrain from, during the 6 month period, appointing the trustee to anything for any period of time within that 6 month period only. If that makes sense. I'm trying to understand it.
And Trustee Campbell, I believe it is to a representative position, so that we're not talking here about membership on a board committee. We're talking about things probably like OPSPA directors and stuff like that.
Thank you. So I just like our council's opinion, just to make sure that this meets the smell test.
Mr. Harnden?
I understand the question, and I would suggest that and you're referring to paragraph F of the draft motion, I take it. I would suggest that there's really 2 6-month periods. There's the one you created by paragraph F, and during that time frame, the direction in the motion is to refrain from appointing the trustee to such a representative position. I would suggest there's another 6-month time frame that would apply to drawing on the code of conduct and preventing you from appointing them for more than 6 months. However, I distinguish from that the power of the board in any appointment in the future to choose whatever trustee that you wish to. So that power still remains, but in terms of it flowing from the sanction, it would only be for a 6-month period.
Thank you very much for that. And I'm probably almost out of time, Madam Chair, so probably put me back on the list. But I'm beginning to think, looking at this, I keep reading it and rereading it, that F may be problematic as it's currently written. Thank you. Please put me back.
Thank you, Trustee Campbell. And as I add you to my second round list, I remind trustees that it is after 10 o'clock. We have a vote at 10:30 on whether to continue the meeting. And then at 11 o'clock, we need unanimous consent to continue. So if we're going to finish this tonight and not have to continue, we really need people to think about how long they speak. Trustee Huff, you are next, and then Trustee Fisher.
Having heard that message loud and clear, Chair Scott, I will jump over my comments of emotion and action and just thank Trustee Schwartz for having captured the sentiment that I think that I'm feeling very clearly. My specifics with regard to this are twofold. Do we need a clause that indicates should she choose not to resign? Do we need to preface the points following that initial statement? And the second one would be, could we include that not only that the trustee be asked to undertake an anti-racism program recommended by the board's human rights and equity advisor, but that she completes it to the satisfaction of the advisor as well. Those would be my 2 points.
And I will ask for a staff response on that, or a legal response. Ms. Giroux?
The second question was with respect to the human rights training and whether it could be to the satisfaction of. I guess I have 2 comments on that. I'm not sure that, and council can clarify, but I'm not sure that since we can only encourage the taking of the course, that we can require it be to the HREA's satisfaction. And I'm also not quite certain about imposing that responsibility on the Human Rights and Equity Advisor and whether that's an appropriate position to put the staff member in, since it's really a board action. Council may have some clarity on that. I think the first question was more a question for council, if I recall correctly.
Mr. Harnden?
In my opinion, you cannot add that additional layer to that sanction. You'll note that the wording is encourage, and I feel that the word encourage is within your authority. Going beyond that is not.
Okay.
And in terms of the necessity of adding reference to should she not choose to resign?
Outside of the board's authority.
Thank you.
Okay. Thank you.
Anything further, Trustee Huff? That's it?
I will pass on the interest of time.
Trustee Fisher?
Thanks, Madam Chair. I really appreciate the opportunity. I wanted to reserve my comments for this portion of the evening. I want to thank for all the comments that trustees have provided so far. I share many of them. In brief, I think all of us, seek public office because we feel in some way that we can, to the highest order, protect and advance the public interest, and to do so, in a way that really builds public trust and public confidence. I fully support the draft sanctions that have been put forward, even if they are amended slightly. I think it's fair to say that when you look at the pattern of conduct in this particular case, which was highly unfortunate, it was intimidating. But I think if you look at the pattern of conduct extending beyond this situation over the last number of years and terms, this certainly isn't the first incident. We've tried to deal with this kind of behavior, in a way that changes behavior. We haven't been effective in that regard. And I think that the sanctions that are being put forward tonight will hopefully do that, if not send a strong signal to the trustee that perhaps it's time to consider stepping down from the office that we believe so very strongly in terms of maintaining public trust and public education in the city. So that's all I really want to say on this matter, but I fully endorse the provisions that have been brought forward tonight, and certainly look forward to further discussion and debate on those provisions, those sanctions, and what we decide to do ultimately. Thank you.
Thank you, Trustee Fisher. Next, I have Trustee Bell.
Thank you, through you, Chair. I am going to cut down my comments as much as possible. I have two questions. One is regarding the mandate that we don't have to ask Trustee Blackburn to step down after committing what is a racist act. And so I know I'm a first-time trustee, so thank you, Schwartz, and thank you, Boothby. I am a first-time trustee, and I know I have a great responsibility to address racism and to act in the highest regard at all times, in public and in private, so that no student experiences bias and barriers that result from racism. So over the past 96 days, we have had countless hours of staff time and tens of thousands, up to $50,000 spent on this case. And meanwhile, we've all been asked around this table what our stance is, and we have had to be silent. I've read the facts, and the behavior is appalling. And we know that systemic racism is real. The fact that we don't have the ability to ask someone who has committed an act of racism to step down is in fact upholding the systemic racism that we seek to dismantle. So I would like to ask, my first question is within, I believe it's part A1, how strong of language can we call out the ultimately racist act of saying that to a Black youth that he could potentially end up in a detention center? And then the second question I have is, should she decide to stay on, is there any clause that we could put in to say, if this happens again, then, and have something harsher at the end of it? Thank you.
Thank you. Do we have answers for the two questions?
I think the answer to the second question is no. There is nothing that.
Could you speak up, please, Ms. Giroux?
I think the answer to the second question is no. I don't think that we can add any conditional language that moves to a tougher action the next time. Assuming that there's no change in the legislation, you'll be governed by the same practice. The first question was, how strong can you go in your language? You have discretion in terms of the strength of the language. And so if the member wants to make an amendment to the language to add additional words, that's certainly within the scope of possibility. Legal counsel may have other things to add.
Well, I agree on both subjects.
Thank you for that. Trustee Bell?
I will move to revise the language in 1A. where it reads, and which used language which is known to be offensive, and more specifically instead of and more specifically a form of, I would say something to the effect of, and which used language which is known to be offensive and engaged in a anti-Black racist act.
So where are you adding that? In part A,
one,
lowercase I?
Yeah.
Are you adding that where?
So specifically where it says, and which used language which is known to be offensive, and more specifically engaged in an act of anti-Black racism.
So what you're doing there is changing the words. After specifically, after specifically, you are adding
engaged in an act of anti-Black racism.
And engaged in an act, or in an anti-Black racist act, or an act of anti-Black racism.
Either way.
So that is the recommendation for the proposal for amendment, which is on the floor. We are in committee at rules of committee at the moment, so we do not need a seconder for that. Is there any further introduction? Trustee Bell, you have just a few seconds remaining in your time.
No, that is all, thanks.
Are there any speakers to the amendment? Trustee Campbell, Trustee Huff, Trustee Fisher on the amendment. Trustee Campbell? I see your hand has disappeared. Trustee Huff, did you wish to speak on the amendment?
I feel strongly that this is a great improvement to the language in point A, and I will be supporting that.
Are there any other speakers on the amendment? If there are none, we do not require to have recorded votes on amendments unless it is so requested. So I call them because there has been no request for it to be recorded. All those in favor? And the motion, and those opposed? And the amendment is carried. So Trustee Bell, I think you were out of time with that. So if you need to speak again, you'll have to come back on the list. And you were my last first-time speaker here. I have 3 second-time speakers, beginning with Trustee Schwartz.
Thank you, Madam Chair. I'm going to turn directly to questions to Council. I'd like to hear from Council's opinion with respect to sort of the maximum sanctions that we've now sort of put forward according to the Education Act. As I read it, these are the maximum that we can go with respect to how the Education Act is written. But I'd like to know if there's been cases in Ontario which have actually launched sanctions that are further than what's under the Education Act. And is there any case law which has actually allowed further sanctions from what we see put in front of us today?
I am aware of boards who have imposed a more severe range of sanctions. In my opinion, they did so beyond the authority granted to them under the Education Act, and I would not recommend them to the board.
What were the rulings of the courts? Was there a judicial review in those cases?
No, there's been no judicial review, no court decision that lends insight to the interpretation of the act. And of course, your code of conduct has similar wording.
So what you're saying is there is no current case law in Ontario?
No.
So I think it's important that the board, and I want on the record that the board should be asking for changes to the Education Act so that we actually do see changes to allow us to take stronger actions when we actually see forms of racism such as we've seen already demonstrated. My next question then is with respect to committees sitting over the summer, and this is directed to the chair. I understand that some of these committees may have to sit over the summer months, such as Committee of the Whole, Budget Committee of the Whole. If I can have a comment from either staff or from the chair regarding how many committees and how often we may need to meet, because I'm not sure if we want to start the sanctions as soon as July 1st.
Well, I can begin, and I will ask Ms. Giroux to add, but certainly we do have Committee of the Whole Budget that we know will be meeting through the summer months although the schedule hasn't yet been determined, I expect there may be additional Committee of the Whole meetings and certainly some board meetings that will be required as we move forward with our planning for September.
Okay, in so far as the other committees then, so Parent Involvement Committee, Audit Committee, hearing panels, expulsion panels, and any ad hoc committee, I'm just wondering if there are any that are currently scheduled for between now and September.
And you are out of time, but I will ask if the director or Ms. Giroux has a response on that. Most of them wouldn't normally meet through the summer, but there may be some meetings that will happen. Ms. Giroux or the director?
At the present time, as the chair indicated, we don't have any scheduled meetings for the summer. We do have a discussion, the manager and I tomorrow, about what a meeting schedule could look like to support Committee of the Whole budget. And there is a possibility of either board or Committee of the Whole needing to meet. We do not currently have any scheduled advisory committees of any of those other groups, although there is the possibility of one meeting that's been under discussion. I haven't had a chance to speak with the superintendent, so I'm not sure what the status of that is right now.
And in that regard, I note as well that there are a number of these committees that Trustee Blackburn is not currently a member of. So moving on then to the next second time speaker.
Can I please be put back on the list? I have additional questions.
And we have limited time as well, Trustee. Please be mindful of that. Trustee Campbell.
Thank you, Madam Chair. So I've asked my previous questions. Trustee Schwartz, I don't want to necessarily steal her thunder, but I'm.
Can you please speak into the mic?
Thank you. I don't want to necessarily steal her thunder, but I'm wondering whether I think I'm getting an understanding of where she's going with this. Do we have discretion as to the commencement of the 6-month period?
Yes.
I believe we do.
Agreed.
Thank you. I'll wait to hear Trustee Schwartz on this. I just wanted to clarify myself. I've asked all my questions, I think, to date. I abstained on the amendment. I'm not personally looking to, in a sense, no disparagement intended, but nickel and dime is a very lengthy motion. I'm generally in favor, and I guess I've been brought to this really, in fact, moved by Trustee Boothby's note that this is a third-time trustee. And what it seems to me here is that there's an effectively unrepentant sort of unwillingness to recognize the proper limits of the role of trustee. And there's basically a disregard for that, and a very poor understanding and appreciation of the actual role of trustee in some important regards here. And at this point, I don't know that that's remediable. And that is why fundamentally I will support this this motion. Thank you.
Thank you, Trustee Campbell. Trustee Boothby.
Thank you, Chair. And I will be fairly brief and take off from Trustee Campbell. And what I'd just like to remind Trustee Blackburn, as well as the rest of us, I feel like with this particular incident, that through this action of hers, she really has lost the moral authority to be a trustee and to help us move our work forward for all students, but in particular, our anti-racism work. And so our board of trustees and the OCDSB is tainted by this action. And I'd like the trustee to really seriously think about that, particularly as it has to do with Part A of this sanction. And that's all I'll have to say on this, but I certainly will be supporting it. And I will also support if Trustee Schwartz would also like to make the committee meetings essentially when they start and then run for 6 months once they have recommenced.
Thank you, Trustee Boothby. And that brings me back to Trustee Schwartz for a third round. And I remind again, it is almost 10:30.
I will go as quickly as I can. In terms of the Education Act, as much as I would love to actually put these sanctions to an 18-month period to ensure that, as other trustees have indicated, that Donna has lost the confidence of the board and of the office that she's been elected to. I also understand the risk associated with doing that. I do believe, on the other hand, that we do need to amend the motion to ensure that we actually are starting the barring of meetings to take place when those meetings, in fact, are taking place. So I understand Committee of the Whole budget will be meeting over the summer, but I'll need a comment from staff as to which ones are going to start when, so that we can appropriately put the sanctions on that. My last bit is really to deal with section F, which is because we only meet in December to choose who sits on which committees. I think that section F is moot. We don't elect people to sit on committees between July and December. So I'm wondering if perhaps we have it start in December at that first meeting, whichever date that actually is, when we choose to have trustees sit on committees, and that it's 6 months from that date. And if my understanding is correct, the dates can be all different depending on when the different committees start. So again, just a comment.
Trustee Schwartz, in the interest of trying to keep this simple, it may be easiest with the dates of the committee to specify those for which it begins, or to simply say something along the lines of beginning with the next meeting of whatever committee is. I'll ask for Ms. Giroux's comment on that, but that may solve part of the problem. Ms. Giroux?
So just to clarify, you're saying that the start date would be starting with the next scheduled, I guess, meeting of the committee and running for a 6-month period.
Yes.
I think that would be fine.
And then for Part F, amending Part F.
Well, let's deal with one amendment at a time. Is that what you're proposing to amend?
That is what I'm proposing to amend, yes.
Can we clarify whether that's for all committees or just for the ad hoc and advisory committees? Because there
For
are
all
differences. For example, the appeals panels, I don't know how many are scheduled or when. We don't have some of those meetings, but we may have others.
So for all of them, as mentioned in Part C, so for the next meeting of any of those. Michelle, if you're talking, you're on mute.
Apologies, I was just trying to bring up the motion. So you want to add, change the date in clause C to all of those committees?
Yes, so it would basically be that the Donna be barred from sitting on the following committees of the board for a 6-month period.
Beginning with the next scheduled meeting of.
Beginning with the next scheduled meeting of.
Each of the following committees.
Yes.
I'm running, right, okay. Nicole, are you good with that?
Is that the wording then? We're good?
And ending it after 6 months.
And if they're not all considered committees, then we just need to make sure that that's referenced as well.
Nicole, if you leave in for the 6-month period at the front end and just delete the between July, I think you'll have it for the 6-month period, beginning with the next scheduled meeting of each of the following committees.
Is everyone clear then on the amendment being proposed by Trustee Schwartz? I will ask if this is a friendly amendment, would you please put your hand up?
I have a question, Chair.
Is that to determine if it's friendly?
Yes.
Go ahead, Trustee Boothby.
Thank you. I'm just wondering, in this list of committees, where does OSTA fit, or has it been excluded from this list?
OSTA is not a committee of the board.
It is not. Okay. Okay, thank you.
So if you see this motion as friendly, put up your hand, and I'll ask in a second if you think it's unfriendly. And okay, I will ask now if you do not agree that it is a friendly amendment. And I disagree with it being friendly, so that amendment is then incorporated. It is accepted as friendly. Second amendment, Trustee Schwartz.
Yes, so for Part F, given the fact that we only do our meeting at the beginning of December to determine what committees trustees sit on, I'm just wondering if we can actually change the period of 6 months to begin that date in December. And I don't know exactly which date that is. I need a comment from staff.
Even if you did it on the 1st of December, usually the organizational meeting is within a day or so of that.
Okay, or we could have it read, refrain from appointing Trustee Blackburn to any representative position or role on behalf of the board during the next organizational meeting.
Chair, it's Mark. I think we have to take the 10:30 vote.
Yes, it is just gone 10:30. I will need 2/3 of those present and voting. Ms. Giroux?
Yes, sorry. Sorry, Manager Guthrie, I think has lost her connection. I'm just looking to see if she's here or not here. Not here. She's trying to dial back in. I missed your question.
In terms of the 10:30 vote, we need 2/3. Is it 2/3 of those in attendance, or is it 2/3 of those who are able to vote on this? I think it includes those people who are recused and non-participants on this agenda item both.
I opened my bylaws a few minutes ago to have an answer to this question and didn't get to this section yet.
I think we already have 9, Madam Chair.
And if we already have 9, that's more than the 2/3 in any event. So that means we can proceed. And getting back to the amendment by Trustee Schwartz to Part F. Could you read it again, please, Trustee Schwartz?
Yeah, so that the board refrain from appointing Donna to any representative position or role on behalf of the board at the next organizational meeting in December 2020.
So,
and that is the amendment. Is that considered friendly?
No, Madam Chair.
It is not considered friendly. Bearing in mind we need unanimous consent to continue past 11. Is there any further discussion on this?
Madam Chair, just to clarify, the amendment was to bar the trustee from being appointed to any representative role at the
No,
next.
it's that the board refrain from appointing Trustee Blackburn to any representative role or role on behalf of the board at the next organizational meeting.
And so just looking to legal counsel to confirm, I've lost track in the moment about the 6-month period. The appointments at the org meeting are for a 1-year period, or in some cases a 2-year period. So I'm not certain if the language keeps us within the scope of the act or policy.
I share your concern, Ms. Roux, that I would recommend that the board stay with the current wording.
Thank you for that advice.
I will withdraw that amendment then. And
do we have agreement for that amendment to be withdrawn? If anybody objects, please put your hand up, Trustee. So we are accepting that it's withdrawn. Did you have any further amendments, Trustee Schwartz?
I will then therefore just amend the language to read appointing Donna to any representative position or role on behalf of the board for a period of 6 months from December 1st, 2020 through to the 6-month period.
And is that friendly? Trustee Penny? Are you saying it's not friendly, or you're saying that it is friendly?
I just responded to your request to see if it's friendly.
Is there anybody who says it is not friendly? And I am not seeing any.
Madam Chair.
Trustee Fisher?
Yeah, I'd just like a comment from legal counsel whether or not that's within the bounds of our authority to start the 6-month clock from December.
Yes, it's within your authority to choose a 6-month time frame.
6-month time frame from December?
Yes.
Okay, thank you.
So is this friendly or not? If it is not friendly, please put your hand up. If it is not friendly, and I'm not seeing any hands to say it is not friendly, so that is incorporated as friendly. Is that it?
I have a further couple of amendments that I'd like to propose. A Part G, which has removal.
We have 20 minutes left for the whole meeting.
I understand, but we also need to make sure that we get through this, and I have amendments that I would like to propose.
Yeah.
I would like to propose that, that the board remove access to professional development funding to trustee Blackburn for the duration of her term.
And I would like to ask for a staff comment or legal opinion on that.
I think that's beyond the authority of the act, but I look to legal counsel for confirmation.
Mr. Harnden?
I don't believe that that's within the bounds of the act.
Trustee
I will remove that amendment, but I did want to make sure that I put it on the record that I do not believe that trustee Blackburn, or shall I say Donna, should actually have access to funds, public funds for professional development to go to conferences or any other type of thing, aside from what we've actually put into the this motion this evening. Furthermore, I also don't believe that during the duration of the sanctions, she should actually have access to email, but I also believe that that probably will also be outside of the bounds of these sanctions. So I will leave my commentary at that, given the late hour, but I really don't believe we're going far enough. But I also understand that we only have so much in the way of recourse and sanctions. And I'm very hopeful that we'll be able to put forward some amendments to the Education Act forward to the Ministry of Education so that we don't ever have to deal with the situation again. Thank you.
Thank you, Trustee Schwartz. We are still in rules of committee. It would be, we will have to take the vote on the recommendation under board rules anyway. So would anybody like to move to return to board rules? Trustee Boothby, you're moving?
No, Chair, I'd like to speak to this again, and I'd like another amendment.
Trustee Boothby, go ahead, please.
So I would like to have Trustee Blackburn removed from her appointment to the OSTA committee. That is a very significant appointment, and she's not only dealing with people from our board, but she's also representing herself with the Ottawa Catholic School Board. So I feel very strongly that she should not be acting in our stead on that board. So I'd like a response from legal. Are we allowed to do that?
Mr. Harnden?
I examined whether or not you could do that as a form of sanction. I concluded that you cannot, in part because you're dealing with a separate organization. The appointment was partly pursuant to the bylaws of that organization. It would, at a minimum, require another board meeting, and then you get outside of the bounds of the code of conduct because you'd be imposing a sanction at a second board meeting. So I'm condensing a whole series of concerns.
Thank you for that. And I will reluctantly withdraw my amendment, but I think that that is very unfortunate that we have Trustee Blackburn representing us on such an important committee that deals every single week with students' lives.
Thank you, Trustee Boothby. And is there anybody opposed? The motion is carried. So moving on back to my main motion speakers list, I would like to, I have no other speakers on my list because this is board, Trustee Campbell, and you have spoken once. I will ask, since Trustee Penny has his motion on the floor, I will ask if Trustee Schwartz could take the chair briefly, please.
Yes, Madam Chair, I'm happy to do that. And it's over to you, Trustee Scott.
Thank you, Madam Chair. The sanctions that are posed here are severe, no doubt about that. But the behavior of Trustee Blackburn represents such an abuse of her authority as a board member, such disrespect and insensitivity towards a student, and such a failure of personal insight to come to a quick recognition of just how wrong a number of her actions were in the March incident. I really feel that severe sanctions are necessary in this instance. With great regret that her behavior has led to the proposal on the floor, I will support the recommendation before us. Thank you.
Thank you, Trustee Scott, and the chair is back to you.
Thank you, Trustee Schwartz, and I now will return to Trustee Penny as the mover for his wrap up, if any.
Thank you very much, Madam Chair. No wrap up required. Thank you very much, trustees, for your comments. It was very good discussion.
And if Ms. Guthrie is back with us, I will ask her to call the vote. Everyone is clear on the amendments that have been incorporated into this recommendation. Does anyone need the motion read? If not, Ms. Guthrie, could you call the roll for the vote?
Trustee Boothby,
In favor.
Trustee Huff,
In favor.
Trustee Campbell,
In favor.
Trustee Jenikins,
In favor.
Trustee Penny,
In favor.
Trustee Bell,
In favor.
Trustee Fisher,
In favor.
Trustee Schwartz,
In favor.
Trustee Scott,
In favor.
I'm still here. I think I should get to the thing.
And the count is, and Trustee Lyra, is anybody opposed? And then Trustee
no.
Lyra is abstaining, yes? So
Yes,
what is the count, please, Manager Guthrie, because you can add it up faster. than I can.
9 in favor.
9 in favor, none opposed, and one abstention and one unable to participate in this vote. So that
Lynn, Lynn, it's Mark. Just to clarify, Trustee Lyra is recusing herself. She's not abstaining.
yes, that's correct, and that's recorded that's recorded in the minutes. But in terms of counting it up, it amounts to an abstention, I believe. So with that, we have come to the conclusion of our voting on this. The board has made its decisions, and in accordance with section 4.41 of our policy, written notice of those decisions will be provided to Trustee Blackburn as soon as possible. Trustee Blackburn, as stated previously, does have the right to appeal by making written submissions to the board in respect of those decisions within 14 days of receiving written notice of our decisions. On behalf of the Vice Chair and myself, I would like to thank staff for their assistance to us throughout this process, in particular Executive Officer Giroux, Board Services Manager Guthrie, and Legal Services Manager Richard Sinclair. And many thanks also to our external legal counsel, Lynn Harnden, who has been with us this evening. The process hasn't been for any of us. It has highlighted a need for further review of our board member code of conduct policy and of the legislation on which that policy is based. We can review our policy ourselves, but at this time, I would like to inform the board that I have in fact drafted a letter to the Minister of Education asking for a review of the legislation associated with this process on the basis of our experience since 2016 in the OCDSB, together with my research into the experience of other boards over that period. The draft letter will be circulated immediately to all trustees via email for their input. And The final version will be completed and sent as soon as possible. It will be a public document. I also want to note that I understand the director has been very concerned about the impact of the initial incident and subsequent events on our students, staff, and communities across the district. We appreciate her efforts to keep our strategies moving forward during this difficult time with respect to creating a culture of caring and social responsibility. Madam Director, would you like to make a closing comment?
Thank you, and through you, Madam Chair. I took the liberty of preparing my statement tonight. So with your indulgence, through you, Madam Chair, while the matters discussed this evening pertain to an issue that is overseen by our Board of Trustees, it is important for me to recognize the overarching principle of equity and human rights that has been raised by the community through this experience. The calls for action sounded by the community have been underscored by the recent attention to matters of anti-Black racism shared not only through the media, but also through the voices of people right here in Ottawa. The trauma that has been communicated by the community at large and the Black community in particular has been clear and resonant. The voices of Black people are joined with Indigenous communities, scholars, leaders, and families who have already shone a clear light on areas where our commitments and responsibilities to human rights have not yet been realized. There is no question that the district, board, and staff together must own the challenge and drive changes that will result in measurable differences for Black, Indigenous students in our system. Classroom curricular programs, content and teaching, leadership and staff representation, discipline policies and procedures are some of the key areas where Black and Indigenous students have been underserved by the status quo. While our work must serve to improve the experience and outcomes for these particular student communities, we know that to achieve truly equitable outcomes for all students, everyone needs to engage with and explore diverse voices, experiences, and perspectives as we learn and work together. When I began my role a year and a half ago, I made a public comment that when the tide goes up, all the boats rise. When we measurably improve the experiences and opportunities for Indigenous and Black students, we will ultimately serve all our students well. This is our commitment in partnership with the board and with the community. Thank you for indulging me, Chair.
Thank you, Director. That brings us then to the next item on our agenda, item 4.3. And for this item, I would like to ask Trustee Penny to take the chair.
Thank you very much, Madam Chair, and go ahead.
You will see in your agenda my notice of motion regarding a potential policy resolution to be sent to the Ontario Public School Boards Association for consideration at their annual general meeting. I've looked at a lot of different boards' policies. I've read a lot of sets of other boards' minutes and our own minutes about dealing with instances of trustee misbehavior. And it seems to me that the existing legislation is very problematic in terms of its scope, particularly because it is primarily punitive in nature and doesn't include any really strong authority for doing things instead of punishing that are actually remedial or restorative. I do think it needs to be reviewed, and I move, therefore, that the board send this resolution that advocate for improvements to Section 218 of the Education Act and Ontario Regulation 246/18 to enhance school boards' ability and authority to address unacceptable or inappropriate behavior by board members. Thank you.
Thank you very much for your motion, Trustee Scott. Your notice of motion, is that a motion or notice of motion?
This is, I've just moved it on the floor.
Okay, thank you very much. And do we have a second? Trustee Boothby, do you second?
I'll second.
Yes, Chair, I second.
Okay, thank you very much. And Trustee Scott, that was served as also your introduction, I suppose?
Yes, it did.
Okay, and we have Trustee Campbell to make a comment or a question.
Yes, I guess I'd just like to understand the reception this is likely to have at OBSPA and where the trustee sees this going, because the motion as stated is very generic, right? Sort of like, please consider things in general. The trustee speaking has specific ideas, I imagine, in terms of what improvements they'd like to see. I may have specific ideas of improvements I'd like to see, and so on and so forth across boards. So is the expectation that OBSPA will consult boards, strike a committee? I guess, what is the expected reception of this motion? And where do we see this going if this were to go forward?
Thank you very much. And I'm going to turn it over to Trustee Boothby, one of our OBSPA directors, to give a little bit of a briefing on the process.
Thank you, Chair, and thank you for the question, Trustee Campbell. I did have an opportunity to discuss this a little bit with Chair Scott before she brought the motion, and I appreciate your questions. I actually asked her to keep it a bit more generic in nature for a couple of reasons. One, there have been many boards that have had, over the past 4 years, some difficult trustee situations and have wished that they could access different types of sanctions that we're allowed under the Education Act. Should this motion pass and we do bring it to the AGM in September, I think it would be very reasonable to ask to have a committee of OBSPA sit down and talk about the types of enhancements we would like OBSPA in general to bring forward. But I thought it was important to get the overall idea on the floor, but without sort of calling out specific trustees or specific boards that had significant difficulties in the past. And also, as far as the reception, I think there will be tremendous support for this motion around the table. And I think the fact that it is more open and will lend itself to a committee and to a lot of input around the OBSPA table, I think will help it pass more easily at the AGM, rather than being so specific that we'll get bogged down in some boards saying, no, I don't like that specific line. Others saying, oh, I want it to go much further. I think this is better dealt with at a committee level.
I appreciate that. It's not in the motion. I would encourage that kind of representation going forward. 2 minutes to go. I'll shut up. Thank you.
Thank you very much, Trustee Campbell. And Trustee Boothby, did you have a question or a comment?
No, I just to say I will be supporting this for all the reasons I've just put forward. And I think we've had a pretty robust discussion around this motion really tonight, and it certainly is necessary. Thank you.
Thank you very much. And seeing no further discussion, back to Trustee Scott for a quick wrap up.
And the only wrap up I will say is that I hope that my colleagues will support this, and some of the more specific things that have arisen in our own experience will be part of the letter to the minister.
Thank you very much. And I'm going to turn it over to Manager Guthrie to call the roll for the vote.
Trustee Boothby,
in favor.
Trustee Huff,
In favor.
Trustee Campbell,
In favor.
Trustee Jenkins,
In favor.
Trustee Penny,
In favor.
Trustee Bell,
In favor.
Hang on, I'm not
Trustee
recused from.
Fisher. I know.
In
Trustee
favor.
Fisher,
In favor.
Trustee Schwartz,
In favor.
Trustee Scott,
In favor, and I note that trustee Blackburn is able to participate in this vote as well, should she so wish.
As well as
Yes. Trustee Lyra,
In favor.
trustee Blackburn,
In favor?
and Mr. Chair, that's unanimous.
Thank you very much. And thank you very much, trustees. 11 in favor, 1 not present. And I'm going to turn the chair back over to trustee Scott at 11 o'clock exactly.
Thank you, Mr. Chair. And we have reached the end of our agenda, and I declare our meeting adjourned with huge thanks to everyone for their participation this evening and for being sufficiently mindful that we actually completed our business. Thank you.
Thank you. Good night, everyone.